Hi, it's Shay from Little Steps Asia, and today we are focused on the topic of demystifying divorce here in Hong Kong. And to do that, we have invited our expert, Jocelyn, who is a leading family lawyer here in Hong Kong. We've had you on a couple of times,
Yeah.
so it's really good to have you back. She's going to be telling us all about the ins and outs of the divorce process in Hong Kong, the finances, the child custody, and answering a few questions along the way. So if you are just starting off the process, right in the middle of it, this is somebody that you're going to want to listen to. And the topic today is going to be very helpful through the process. So welcome. Welcome back.
Thank you, Cher. Thank you for inviting me again.
Yeah. So Jocelyn, tell us just a little bit about yourself and how you got into the family law space and where you are right now before we get started.
Right. So I started practicing family law very early on, right after I graduated from law school. So while my peers all went to the corporate law, kind of commercial law, M&A, and all those really profit-making kind of practice areas, I was the lone wolf who ventured into the family law space. I decided to be a family lawyer because I wanted to serve individuals, people, rather than corporations or entities. So I started practicing when I was so it was the year 2007
Okay.
that I started exclusively practicing family law. And that's the only practice area that I've ever done up until now. And it still gets me very interested and exciting to go to work every day because I hope it will show that family law, i.e. matrimonial practice, is a very interesting area of law. So I became a partner at Withers in 2018. And then subsequently in 2022, I became head of the family team at Withers. We have currently 11 lawyers, all just exclusively doing family law. And in 2023, I became managing partner of the Withers Hong Kong office.
Excellent. Well, we've got to hand it to you because family law cannot be always easy. But the fact that you've just brought in your experience and your passion to know the ins and outs, it's really being able to rely on a lawyer through this process. So why don't we just get started with the nuts and bolts of the divorce process in Hong Kong? It's overwhelming, right?
Yeah.
So if you could just maybe break it down. Let's start with the grounds for divorce. What are the
Okay.
grounds for divorce in Hong Kong, for example?
Right. So there are 5 main grounds of divorce. One is the most commonly used grounds, which is unreasonable behavior. So that means that the other person have behaved in a way that it is unreasonable for one to expect you to continue living with that person. So
And
that's
that can be quite broad, right? It doesn't have to be specific.
Yes, exactly. And currently, actually, amongst the family law practitioners, we usually advise clients to, if they choose to use unreasonable behavior as the petition grounds, to use mild version of unreasonable behavior, just because the whole objective is not to go through a contested main suit on why and what caused the breakdown of the marriage. So mild particulars of unreasonable behavior can be as generic as saying the other person hasn't shown me love or affection, the other person hasn't been able to communicate with me effectively, or that we just have different values and attitudes in life. So it can be as neutral or generic as that. And the court currently still accepts these kind of petitions.
Okay.
So that's number 1, unreasonable behavior. And then the second ground that people would use would be adultery. But adultery is a much harder ground to prove because the threshold is pretty high. You need to prove that there has been intercourse, penetration even. So we usually don't advise people to go on adultery grounds and maybe use the unreasonable behavior where they can mention the fact that the spouse has been having an affair as well. So that's the second ground. The third would be 1 year separation, and the second would be 2 year separation. The difference is for 2 year separation, the other spouse doesn't need to consent to the divorce. And so the main suit, as in the divorce itself, is something that cannot be controversial if it's a 2 year separation. And then finally, it would be the grounds of abandonment, which is the person has abandoned the family, has left, has disappeared, that kind of scenario.
Okay. I assume when you have your first meeting with a client, this is one of the first things you talk about, and you're trying to manage what they would like to say versus what would be the smoothest process as well.
Yeah.
How do you go about doing that?
So
Got a lot of energy coming into the room, I'm sure.
yes, well, First of all, they always need to explain to me the background as to why they're here, what caused the breakdown of the marriage, etc. And I would also need to gauge where they're coming from. As in, some people are very pragmatic. They just want to deal with the divorce, as in the financial matters and the children matters, as more important. And as to the main suit, i.e. the divorce, they're not really that concerned about. So for those kind of clients, they would follow my advice and go for, let's say, mild unreasonable behavior or 1-year separation, those kind of grounds. But there are also a different type of clients who feel very upset about the fact that they're have to go through this divorce, and they really want to, as a matter of principle, want to put it on record that the real reason for the divorce is X, Y, Z. And for those kind of clients, they would choose to either go through use the adultery as the grounds of divorce, or really put specifically what are the unreasonable behavior. So I just need to respect what they want. Ultimately, even if they started on something which is acrimonious, an acrimonious kind of petition, they can always try to amend it or seek a way to resolve it with the other side to make it a more neutral for both parties. So it's not that they started off with one kind of petition and they can't really change later on.
Yeah. Okay. So maybe we could just talk through the process a little bit about the filing process. So you meet your client. You've agreed on a reason. What's the process that takes place, and how long does it typically take place to deliver the files, essentially?
So drafting up the divorce papers is very easy. Right. Actually, it takes maybe 1 or 2 working days at most. But the first step would definitely be that they need to sign the divorce petition and need to file it to court. Then they need to serve it to the other spouse. And the service has to be preferably personal service, as in we really need to find the person and say, are you so-and-so? And if they said yes, then we need to personally hand deliver the document to them. And then about 3 months or so, there would be a first court hearing. And the first court hearing is a very non-substantive kind of court hearing, just housekeeping, where the judge wants to find out, whether or not there are financial and children issues. If so, the judge would direct certain evidence to be filed. So, for instance, on the financial side, prior to this first court hearing, actually parties already need to exchange financial disclosure and file it to court. So at this first court hearing, the judge would want to know, are there any other questions on the other person's financial disclosure? If there is, then the judge would direct that parties file a questionnaire, which is to challenge the other person's disclosure, be it asking for more financial statements or asking a person to explain certain parts of their assets or income, or asking them to justify their reported expenditure, etc. So that first court hearing is just for the court to ascertain, are there any outstanding financial disclosure issues, which usually there are. On the children aspect, this first court hearing, the judge would want to know, are there any disputes on custody, on care and control, which I will explain the concepts later on.
Yeah, we'll dig into it a bit more.
Yeah, because a lot of people have misunderstandings about that. But basically, the judge wants to know if there are any disputes on children matters. And if so, then the court will direct a social investigation report, which is a social welfare officer coming to interview the parties, the children, if they are of age, and also having observation sessions. And then ultimately, the social investigation officer would write a recommendation as to what should be the arrangements. And then there is a second court hearing, which is also the similar nature to the first, where the judge would bring everyone back to say, now that we have on the financial side further disclosure, are there any other issues? On the children aspect, there is a recommendation. Do you parties want to follow the recommendation? And if the answer is they still want to contest on these matters, then the court will adjourn the case, or advance the case rather, to a second stage, which currently we call case management hearing. But it's really where the judge would analyze the whole case and say, from here on, when would be the milestone court hearing date? So first of all, the two. One would be what we call an FDR, Financial Dispute Resolution hearing. And for the children matters, it would be CDR, Children Dispute Resolution hearing. So the court will fix a FDR or CDR, depending on what issues there are. And these kind of court hearings are actually not where the judge makes a determination. The judge's role is there to help parties settle. So we often call these kind of court hearings settlement court hearings, where the whole objective of everyone concerned is to try to negotiate a settlement with the judge's help, as almost like a mediator. So the judge would give indications, would make comments about the case to say, oh, I believe if you go to court to fight over it, I think the judge would likely order this and that. So you guys reconsider your positions, etc. So usually nowadays, most cases should settle at either the FDR or the CDR hearing because the judge is there just to help parties to come to a compromise. But if for some more complicated cases, the party still, for whatever reason, does not want to agree with the judge's recommendations or even agree with the other side on their terms, then the court will fix the whole case to the final stage, which is called a trial hearing. So a trial hearing is what you see on TV or movies where the parties actually need to be in witness box to be cross-examined, to give oral evidence. It can take up to days or even weeks if it's complex. And the judge ultimately at the end of the hearing will make a decision on what should be the financial arrangements or what should be the children arrangements. But it's important to understand that for finances and children matters, they are separate, although they may run in parallel, but they are separate matters. So the court usually would deal with the children matters first and put a pause maybe on the financial matters until the children matters are resolved. Then the court will move on to adjudicating on the financials.
I think I went through a process here in Hong Kong, so I recognize a lot of these processes. And I guess there's just a few thoughts that I had was, first of all, if I was thinking about getting a divorce, what you just explained is the full gamut of what you can go through here in Hong Kong. But that's not as common to kind of go from start to the end in the court boxes. What would you say is more of the common path that you see here in Hong Kong? Is it settlement or?
Yes.
Yeah.
So if you have to go through the whole process I just explained, it probably would take years. Not a lot of people, yes, not a lot of people have the appetite, financially or emotionally, to undergo that kind of lengthy process. So nowadays, a lot of people settle outside of court, whether through mediation, which is a way where they both engage a mediator who can also be a family lawyer, but the mediator's role is to help parties settle. So they are not representing either sides. So a lot of cases do settle at mediation. And mediation can happen in parallel anytime before or during the divorce proceedings. And if the case settles at mediation, then the whole procedure falls away. So it can take a few months or a year for parties to settle outside of court if they wish to. Again, I mentioned the FDR and the CDR, which are also court hearings where it's very effective. The parties do settle at these kind of hearings. And if you were to go until that stage, it usually, I would say, take about 18 months still. So we usually advise clients to try to find ways either to settle with the spouse through mediation or even direct negotiations. In a lot of my cases, parties may start off with like guns all blazing kind of a approach, say, oh, I want to litigate on this and that. But gradually they would be quite worn down. And then they might want to, hey, actually, we don't want to spend so much money on legal costs. Why don't we just sit together and settle on a deal kind of thing? So there are a lot of cases actually that settle without undergoing the entire process.
It's amazing. Amazing. A lot of patience.
Yes.
So I know a common question that comes up, it certainly did with myself as well, is does it matter where you were married in terms of if you're divorcing in Hong Kong, maybe you were married outside of Hong Kong? Can you just tell us a little bit about that question that you might get often?
Yeah, that's an excellent question because actually this morning I had a call from a potential client where he was married in Canada.
Okay.
His wife is, he's American. His wife's European, I forgot which country. And they moved to Hong Kong just last year. So pretty recent. And he's asking, oh, where should I divorce? And he's asked Canadian lawyers that he can't divorce there yet because he was only married there, but that doesn't qualify him to divorce there because he's no longer residing there. And so Hong Kong is the only place that he can divorce if he wants to. And so I had to advise him on the the grounds of how a couple can or cannot divorce in Hong Kong. So currently there are three ways a person or a couple can divorce in Hong Kong. So the first is domicile. So if you're domiciled in Hong Kong, as in you're a Hong Kong permanent resident, you treat Hong Kong as your permanent home. Obviously, you live in Hong Kong, then you can use domicile as a ground. Usually, expats can't rely on this ground because they usually won't be domiciled in Hong Kong. The second would be that you're habitually resident in Hong Kong for 3 years or more. Some expat can qualify using this ground because they've lived in Hong Kong for over 3 years or 3 years. And if for the example that I just mentioned, where they have not been living in Hong Kong for 3 years, then the only last ground that they may rely upon is the substantial connection. So that's saying, okay, even though I haven't lived in Hong Kong long enough, but I have a substantial connection with Hong Kong. And this concept of substantial connection is very vague. However, it's nowadays it's more and more popular for people to rely on this, primarily because there's a lot of cross-border divorces, like a lot of PRC couples. Maybe one of them lives in Hong Kong, or they have businesses or assets in Hong Kong, but then they are still living in the PRC. So for them, they would usually rely on substantial connection. However, substantial connection, as I said, is very vague. There's no definition as to what would constitute substantial connection. It's all on a case by case basis, and it's up to the judge to decide if the facts of the case are sufficient to say that there are substantial connections with Hong Kong. But yeah, substantial connection is a ground which people may use, and I've just advised the client who just called that perhaps he can try, but there's no guarantee that the court would accept that there has been substantial connection because they've just been living here for a little more than a year. They have maintained bank accounts in Hong Kong. They are working in Hong Kong and earning an income. But whether or not the court feels that it's sufficient, it's up to the judge to decide.
Okay.
Yeah.
Okay. So while we're kind of on that topic, what would you say are the advantages, disadvantages of filing here in Hong Kong versus, say, Canada or US, or what's interesting about the divorce process here in Hong Kong?
Okay, so I think a lot of people argue on jurisdiction, as in when they are considering divorce, they would think about which jurisdiction is more favorable to them. That's natural. And so they would compare jurisdictions. And just so happens Withers, the law firm I'm in, we have family law teams in Singapore, US, London. And so I'm able to actually know a bit about those other jurisdictions. Generally speaking, we follow London law, UK law. And so generally speaking, in Europe, London is considered the most generous place to divorce for the financially weaker spouse. And in Asia, actually, Hong Kong is generally considered the most generous to the financially weaker spouse as well. So there's a lot of divorce. We call London the divorce capital in Europe, and Hong Kong the divorce capital in Asia, just for that purpose, because a lot of people would want to choose to divorce in Hong Kong. So, for instance, in terms of financials, if you compare Hong Kong with, let's say, Singapore or the US or even Canada, France, those kind of countries, in terms of the nature of assets which we consider as something that can be shared with the other spouse, whether it's premarital assets, inherited assets, or gifted assets, which by nature is non-matrimonial, nothing to do with the marriage, we still would count that as part of this pool of assets to be considered as to, okay, how much should the other person be sharing in it? For other jurisdictions like Singapore, US, they have this very clear distinction to say, okay, premarital assets are excluded. So they're not going to be, there's no possibility of them being shared, except if that premarital asset is somehow used in the marriage. So if there's a property and it's used as a matrimonial home, or if the premarital asset is commingled with matrimonial assets. Say there used to be this bank account, and then during marriage, the person still continues depositing money in the same bank account and then using the same bank account for the family's expenses, then it's considered commingled. In that case, it's hard to draw the line as to what part of this bank account is premarital and post-marriage. And so only if those kind of instances occur. Otherwise, in those jurisdictions, they just disregard the premarital assets. Whereas in Hong Kong, we look at everything from the get-go. And then if 50%, which is half of the assets, is more than enough to cover the other spouse's needs, then the court will entertain arguments such as, okay, should I be looking at certain assets to be excluded from sharing because it's non-matrimonial by nature, etc. But the first and foremost condition is that the assets has to be huge enough to cover for both parties' needs. If the assets are very limited, then the court probably would not consider excluding certain assets just because they are premarital or just because they're inherited, etc. Having said that, nowadays, there's a lot of divorces, and unfortunately, a lot of divorces are marriages which are very short in length. So for short marriages, and there's no definition as to how long or how many years would be considered short marriage. But in my experience, if it's 5 years or below, it's considered short. So for short marriages, the courts usually would exclude premarital assets because, one, the parties are young enough that they don't need to rely on the other person's assets. So that covers their needs, and they may also be working and earning an income. Second is that the majority of assets in short marriages naturally would be from acquired prior to marriage. And therefore, it wouldn't be fair for the person to be married to someone for 2-3 years and then share half of their assets. So for shorter marriage, there is an exception there.
Okay. This is good information to understand. I think there's just like these, I find Hong Kong law to be, you can understand it. It's quite,
very based on common sense.
Yes, and fairness.
Yes.
And but there are some of these kind of questions, short marriages, and we'll get into more of the finances and the custody questions that come up. What's interesting, I find, about Hong Kong is how many international couples. So like you said, at Withers, you're having to talk to different colleagues all over the world because you're seeing people marry and divorce from
elsewhere.
Different countries. So it's it's quite interesting.
Yeah.
What if the spouse does not agree to the divorce? So what if one person wants it and the other person is like, not going to happen? What would you say?
Which is very common. And a lot of clients in their first meetings with me when they decide to divorce are worried about this. But usually, in my 18 years experience, usually it's not going to be a problem because even if the other spouse is very adamant about not divorcing, even if they file in some document which is an acknowledgement of service to say, I defend the divorce, somewhere down the line, they will find a way to resolve the main suit, which is the divorce itself, because no matter if it's the lawyers or the judges, they would all encourage parties to find a way to come to compromise on the grounds of a divorce or the divorce itself, because otherwise a contested divorce would mean that there's a separate court hearing just to argue on whether or not you have cheated on me, on whether or not you have behaved unreasonably. And this court hearing is open court. So anyone can just walk in and listen to all the dirty laundry being hanged out. So,
oh, wow. I didn't realize that.
Yes. Usually cases don't go through the contested divorce route unless if the person is, super religious and as a matter of principle, they don't want to divorce. But it's just a waste of time and money because the cause of the breakdown of marriage has nothing to do, no impact whatsoever on the finances or the children arrangements. And so even if one person at the very beginning says no, absolute no to divorce, somewhere down the line, he or she will accept that the divorce is happening because the judge actually will continue to make the directions that parties need to file X, Y, Z in terms of, like, say, financial disclosure documents, etc. So the case is not going to be put on a hold just because a person says, I don't want a divorce. So that's why eventually, in my experience, the person who was reluctant at the beginning will eventually accept reality and move on.
I think that's a big part of your job, probably, is just explaining the realities. And I think all this stuff adds up, right? So it is important to understand the realities of time, of money through each of these different processes. So
Mm.
kind of keep the therapy over there and keep the divorce process here. So I want to just shift gear a little bit. There's two areas that, as you mentioned, are separate, but they're the two beasts of divorce. The first being finance, the second being children.
Yeah.
So let's just dive into some of the finances, a hot topic. How does the court divide assets?
So there are 5 steps for the court to deal with asset division. Now, asset division is separate from maintenance. So I'll get on to explaining to maintenance later. But in Hong Kong, there's these two different elements.
We need like a tree, right? Assets and maintenance.
Yeah.
Okay.
2 main elements of the financial piece in a divorce. One is asset division. One is maintenance, spousal maintenance. In the US, they call it alimony. So first, the asset division. The court will look at all assets, whether it's under the wife's name, the husband's name, joint names, everything under the sun, including not just bank accounts, investment accounts, properties, but even including a person's valuable items like cars, jewelry, or like expensive watches, everything, pension as well, everything would be put into the same pool. And then the court will, as a starting principle, always apply the 50-50 division rule. So it always starts off with having equal division of the total assets. Now then, once the court has ascertained how much is in the pot and what this 50% is, then the court will look into a person's needs. Now, needs, again, is a very case-by-case kind of concept. It all depends on how much the person has been spending. What is the standard of living that the person has enjoyed during the marriage? So it can be very different from household to household. It's not going to be a percentage of person's income. It's really dependent on the person's expenditure level historically. So the person's needs would be his or her expenditure, also his or her age, because the younger you are, the presumption is the higher it is that you're able to continue earning in the years to come. So the person's age, the person's earning capacity, whether they are working or not working. If you're not working, you may still have earning capacity because you may be university educated, qualified, etc. So the court looks at a person's needs in this way, compare it with the entire asset, the 50% of the assets, whether or not 50% of the asset pool is sufficient to cater for this particular person's needs. And if the 50% is sufficient to cover for this person's needs, then the court will look into other factors, which I mentioned just now, which is, okay, perhaps there are certain assets which shouldn't be shared with the other spouse because of their nature being non-matrimonial, or that, I should be looking into deviating from this 50% because it may be a short marriage, etc. So only if this asset pool is big enough, then the court will look into these arguments to see if there should be any deviation from this 50-50. If the asset pool, the 50% of the assets, is not sufficient to cover or barely sufficient to cover the person's needs, then the court will stop the process there. It's going to be the 50%. And maybe even on top, ongoing spousal maintenance, because with the 50% of share of the assets, the person has not enough finances to sustain his or her living going forward. So on top, there would be ongoing financial support. So that's the asset division. Nowadays, there's a lot of disputes on what constitutes the assets, because there's a lot of intermingling between first generation and second generation wealth. For example, in Hong Kong, it's very common for parents to fund the properties for the children, put it under the names. In a divorce scenario, this child who's an adult, obviously, may argue that, look, this property is completely funded by my parents. So even though it's under my legal title, I'm not the beneficial owner. My parents actually own this property. And if there are these kind of arguments, then the court will need to adjudicate, okay, is this property really owned by the parents, or actually it's a gift from the parents to that adult child? So there's all these kind of beneficial ownership arguments. There's also going to be arguments on, because currently, nowadays, a lot of people understand more about divorce law and how gruesome it is going to be in terms of parting with your wealth. So people may try to dissipate assets. And if there's situations where persons have tried to dissipate assets away by transferring it to third parties, the family members, etc. Again, the court needs to look into, okay, are those kind of assets going to be clawed back to the matrimonial assets to be shared, or are those transfers genuine, in which case I'll leave it alone. So the court needs to ascertain how big is the pie in order to say what the 50% is. So that's the asset division. On the spousal maintenance, as I mentioned just now, if the asset pool is so huge that 50% can already cover the person's lifetime needs, then the court may not order spousal maintenance on top. However, if the 50% of the asset is not sufficient to cover for the person's needs such as housing and day-to-day living expenses, then on top, the court will grant spousal maintenance, which is an amount of money that the financially stronger party needs to pay the financially weaker party in order for that person to sustain their living or expenses, including rental and personal expenses. Spousal maintenance, the amount, again, depends entirely on the historical expenditure level, so the needs. For the duration of the spousal maintenance, traditionally, it's always been until death or remarriage, until the spouse dies or remarries. However, nowadays, the trend from the court is that the courts want to encourage people to be self-sufficient. So it's very rare for there to be until life or remarriage kind of duration of spousal maintenance, unless if it's a long marriage. We're talking about, let's say, 15 years, 20 years kind of long marriage. The person at the time of divorce is already like close to 60s. It's almost impossible for him or her to regain their earning capacity. Only in those cases, it will be a lifelong kind of maintenance. Otherwise, the court will restrict the maintenance to a certain duration. But how long that duration is, again, there's no formula. It all depends on the judge's discretion, looking at the facts of the case, looking at the duration of marriage, the age of the parties, the standard of living, any particular compensation or contribution that should be factored in, and the court will give an assessment, okay, it should be X number of years. In my experience, usually if you're talking about a marriage of, let's say, 8 years or 10 years, the spousal maintenance should be around that length of time. And sometimes we tie it with when the youngest child reaches independence, because that's when the caregiving parent can then perhaps have the time and capacity to take on work when the youngest, let's say, reaches university or even graduates from university. So sometimes spousal maintenance is tied to the children as well. So that's spousal maintenance and asset division.
Okay. So just a few micro questions in there. What about gifts? So things that were given to you from other people or from your spouse. Are those part of the asset pool?
Still counted,
so
yes.
The wedding ring?
Yes, the wedding ring. Even though it's from, let's say, husband to the wife, but it's still, the wife still needs to take the wedding ring and say, okay, this is part of the matrimonial
Got it.
assets to be valued and shared, yes.
Okay. And then a question on, you've mentioned needs. So obviously there's needs like a house, and then there's needs like a facial.
Yeah.
Where's the line there? Is it current expenses? Or?
Yes, they're actually, and that's why Hong Kong the jurisdiction is very generous to the financially weaker spouse, because when we look at needs, it can be anything that the person has been habitually spending on. So there are some spouses which are very frugal. There are some spouses who spends luxuriously. It all depends on what has been the average historical expenditure.
As a couple, this is what we're doing kind of thing.
Yes, and as long as it's within affordability. So sometimes when parties divorce and they're relying on one income may not be able to sustain two households, because the spouse will be separating, two households of the same high standard of living. And in that case, people would need to make ends meet, maybe adjust their living standard downwards in order for that one income to meet the party's needs. However, if affordability is not an issue, then let's say the husband would be obliged to support the wife at the expenditure that she was used to. So that includes if she does a lot of facials, she buys a lot of handbags, if she goes to high teas with the ties, that is still considered her needs, because it's what we say in legal terms is generously assessed. in terms of needs.
Okay. Okay. So when you have a client come in, for example, they have now separated houses. It might be affordable. It's maybe not. What is your recommendation in terms of continuing to spend while they go through this process? Keep it status quo?
Yeah, generally, if it's the spender, I would encourage them to continue spending what they have been. There's no reason why they should be adjusting their expenditure. For the payer, I would also advise them that they need to continue paying what they have always been paying. So the financial status quo needs to be maintained. Because if not, then it triggers an immediate, what we call a maintenance pending suit, which is an application to court during the divorce or even at the start of the divorce proceedings to ask the court to order the other spouse to pay interim maintenance, so interim financial support. So for husbands who suddenly cut off their wife's credit cards or suddenly reduce the monthly allowance, that would trigger the wife to issue a spousal maintenance application. And the court has the power to immediately say, you shouldn't be doing that. Please pay X amount. You don't need to necessarily wait until the final financial adjudication before a person has to pay the monthly support.
And how fast can they turn that around? Because I'm sure that has come up. The credit cards get canceled. You've got to pay your bills. What do? You come to you.
Usually it takes at least 6 months for the court to come to decision. Because you need to file the application, you need to go to a court hearing for the directions, for the housekeeping, and then the substantive hearing for the judge to hear the case substantively, hear all the arguments and make a decision. However, if it's a situation where, let's say, the wife really needs the funds because otherwise she has no means to sustain her living or her children's, the judge has the power to order what we call an interim maintenance on the first court hearing, which is to deal with directions, but the judge still has the power to say, okay, without even hearing both parties' arguments, just looking at the parties' preliminary financial disclosure and let's say the wife's statement, I think, husband, you should pay X amount. So the court actually has the discretion to do that for urgent cases. So that would be about 2 to 3 months after filing the application.
Okay. So that is a breath of fresh air, I think, for a lot of people, because there's a lot of, that's huge fear when you're going through that process, I'm sure.
And a lot of spouses use finances as a means to exert control and pressure. So
you need a good lawyer. So let's talk about the children's maintenance, how that's, we've talked about the spousal maintenance and the assets. Could you just break down how children's maintenance is
so children's maintenance is slightly different from spousal maintenance in terms of its duration. So in terms of the duration, there's no argument to be had. It's definitely going to be until they finish full-time education. Hong Kong is slightly more generous than other jurisdictions. Again, Asian culture, we generally believe that parents should still support their children, even though they're adults, until they finish university education. And therefore, in Hong Kong, it's until they finish full-time education. If they decide to take up a lawyer's degree or doctor's degree, then until that finishes, until they are able to earn. The amount of children's maintenance is similar to spousal maintenance in the sense that it's all dependent on what they currently need. So we'll be looking at not just their direct expenses, which are their school fees, the clothes that they wear, school bus, extracurricular activities, holidays, those kind of things, but also a portion of the general expenses. So a portion of the rent for the house that they're living with mom, for example, a portion of the utilities that they spend in that household with mom, the helpers' fees, any like household tissue paper, toiletries, those kind of expenses. So a portion of the general expenses, usually, let's say if it's a mother with 2 children, then the children's expenses would be 2/3 of the general expenses would be classified as part of children's maintenance too.
Got it. Okay. So it is quite, again, straightforward. You take your expenses and you divide it by the amount of people that need those expenses. And that's a typical number that you can kind of work with. So in terms of, I guess, factors that can influence children's maintenance up and down, is there anything that you would classify in that area?
Well, it has to be really according to what the children spends. So it's very difficult to massage the figures because.
What about future expenses?
Oh.
Let's say like braces, or if you've got a child that has special needs and might need additional education. Any of these that might have some fluctuating, we don't know.
Yeah. Actually, a lot of clients ask me, if we're looking at current children expenses, but their expenses will surely increase. So how do I go about that? Usually for two categories of expenses, namely school fees and medical and dental fees, we, instead of putting down a figure, an amount that, let's say, the father needs to pay the mother every month, we actually ask the father to undertake, which is a legal promise to court, to undertake to cover those categories of expenses. So it doesn't matter that the school fees increase in the future. The father or the husband has agreed to pay and cover that, then he has to pay it. So we deal with that in that way. For children who have special needs, the same goes with any therapy expenses that they have, but also for children with special needs, if they are of such a degree that they possibly may not be able to be self-sufficient or self-sustaining in the future, even after they finish school, then part of the settlement negotiations or even part of the argument that we are going to make to the court is that we need to reserve an amount of capital for them in the future, because they are not going to be able to find a job and become financially independent. So we need to, out of the asset pool, carve out a sum for them, reserved for them, and then the rest are split between the spouses.
Okay. Yeah. So it sounds like a lot of what you're saying is you have to get organized. That's a big part of it, right?
Yeah.
Really need to get the spreadsheets out and
exactly.
get
you
to
need
know
to know
your
figures.
and I think that's a byproduct perk of going through the divorce process, because I have to say for myself, I've never been so organized with my finances in my life. I knew every coffee by the end of it, you know? So it is something that you can say there is that perk.
True.
I wanted to ask about, let's just say, you don't know anything about what your spouse is making or where the credit cards are, and you just come in, you just find out you're getting a divorce. You don't know anything. You've just been kind of doing the day-to-day. What would you tell that client?
Well, don't worry, is what I tell the client, because in Hong Kong, the process or the legal system is so protective of the financially weaker spouse that there's a lot of avenues and ways for a person to find out what the other person has in terms of assets and income. So that's all part of what we call a financial discovery in the divorce proceedings. So first of all, in terms of financial disclosure, both parties need to file we call a Form E, which is a financial statement, a very lengthy one, to disclose everything, be it bank accounts, investments, pension, income, expenditure. So that's only the first round of financial disclosure. Usually, I would say 9 times out of 10, people are not honest in their first round of financial statement. And therefore, it's very common to have a second round of financial disclosure called questionnaire and answer, where we as lawyers, and sometimes even with the help of accountants, really look into all the statements that the person attached with the financial statement to see if there's been any irregular or suspicious transactions in his or her bank accounts, investment accounts, etc. Or even if there's a hidden property, we would look at, is there a regular amount that's been withdrawn from the account, maybe to pay mortgage, maybe to pay management fees, etc. So we'll look at all these financial documents to see if there's any evidence of hidden assets or dissipation of assets. And maybe even for income, for example, if the person refuses to provide any proof, then we'll ask for tax returns. We'll ask even for him to ask his employer, please, to write a statement saying what he has been earning, etc. If he has any, because there are some income structures that are very complicated, and we may ask the person to give more proof as to what exactly is your remuneration package. So this is only the second round. And if the person still refuses to give disclosure, then we can take out a specific discovery application where the court actually orders the person to provide the disclosure. Obviously, the court has to be satisfied that it is relevant and a necessary disclosure. We may even, to the extreme, ask for third-party disclosure, which is to ask, let's say, a bank to say, you need to provide information on this person's bank account, or ask this company provide certain financial statements to show what this person has been earning or what the assets in the company are, etc. So in Hong Kong, there's a wide range of things that a person can do to, we call investigate and dig into how much the other person actually has or earns.
Okay. So in summary, be honest, do the Form 8 correctly.
Yes, because
And-
there's also cost implications.
Yeah.
So if we have to go through all these and at the end we find out something that the other person has not disclosed, that person needs to pay back the legal costs.
And I assume all along the way, it just doesn't look good for the courts because
Yes.
they make note of these things.
Exactly, because usually one judge would sit through at least a good half of the proceedings until it advances to another stage. So it's not going to be in a person's favor if if the judge finds him or her dishonest or not credible, etc. And that would actually affect other aspects of the case as well, including children, for example, because the judge would think, oh, this person is dishonest and mean. I don't want to help him or her.
Oh, gosh.
Yeah.
Well, I do think it is a process. And I think just the way that the lawyer plays a key role in just breaking it down. But if you can do a lot of it between yourselves and just be honest and put the spreadsheets together, that also saves a lot for the lawyers in the process.
Of course.
And just the peace of mind.
Yes.
Well, let's shift gears. Let's go into the custody side, which is obviously the touchy. It's the one that
most parents care about.
Most parents are just it's a tough one. Can you the first thing obviously that we need to talk about are the terms. That's care and control, that's SS, and then custody. So if you could just break those down for us.
Sure. I think it's important for people to understand what those concepts mean because there's been a lot of confusion about the terminology. So first of all, custody. Custody means decision-making, major decision-making. So usually, in most cases, it should be joint custody to begin with because the court doesn't want to deprive a parent of the ability to make major decisions for the children. So custody usually is not going to be controversial. There are some cases where instead of joint custody, it should be sole custody to one parent, but those cases are more of an exception. And for those cases, one would either need to say that the other parent has disappeared, has not been able to find that parent, or that the parents' relationship are so conflictive that they are not able to agree on anything, be it the children's schooling or medical decisions. And if there's a pattern of these two parents not being able to agree on anything just because they are so upset at each other, then the court may believe it's in the best interest of the children to vest custody in just one parent because otherwise nothing gets moved for the children. But it's only in that kind of scenario where there's been a pattern of the parties not being able to cooperate and come to an agreement. So that's custody. The second element, which actually most people fight about, is care and control. Care and control actually means with whom the children lives with.
And there can only be one. Care and control?
Currently, it's actually also quite common for there to be shared care and control. So care and control, yes, with whom the children spends their time with. Usually, if there's one parent who is the primary carer, usually it would be the stay-at-home mother, for example, then she would have care and control of the children because she's the primary carer. She knows best the children.
Just day to day.
Day to day, what they need to eat, what their usual daily routine, etc. However, nowadays in Hong Kong, there's a lot of parents who both work and there may not be a particular parent who is managing everything because they both need to work. In that case, sometimes shared care and control can work, where the children would be spending half of the time with mom and half of the time with dad. However, for shared care and control to work, first of all, both parties need to be able to cooperate because there's going to be a lot of transitions, as you can imagine, between when children needs to be shuffled between two homes. There's a lot of in terms of packing up of school bags or going to this extracurricular activity or school bus arrangements. A lot of things needs to be organized. And so if the parents can't really cooperate with each other, then shared care and control is not going to be effective for the children. Also, the parents need to live fairly close to each other because the children are really going to spend half of the time with mom and half of the time with dad. And you want to minimize the time for traveling between two places. Also, obviously, shared care and control, in order for it to work, both parents need to be capable of handling and taking care of the children, because there are some cases where I've had clients who proclaim that they are capable of handling the children, but actually they are just instructing the helper to do all the things. And when it comes to the children being sick, for example, they don't really know what to do, etc. And so you really need to make sure that both parents are equally, solely capable of looking after the children. If so, then maybe shared care and control and work. Lastly, one thing to note is that the children preferably should be maybe in high school, where they are mature enough and of an age where they can manage their own affairs. If the children are still very young, shuffling between two homes may not be really in their best interest, especially for young children, like toddler age. It's always preferable for them to stay in one home base, because they need that sense of security and stability.
Okay. Good to
And
know.
then last would be access. So the parent who does not have care and control would have visiting rights, which is access. Access usually for a non-care and control parent during school term would be Monday to Friday, 1 day or even 2 days of the week, maybe have dinner with the children or have an activity with them. And then the weekends would be shared between the parents, irrespective of whether or not they're the care and control parent or not, because weekends are quality time where the children doesn't need to go to school, the parents don't need to go to work, and usually it should be equally split, unless a particular parent is not capable of looking after the children in that way. So that's a school term access. In terms of holiday, there's also holiday access, and the children's school holidays are usually going to be split equally. That happens in almost all cases. That's a general principle, no matter who's the care and control parent. And in terms of actually how to split the school holidays, we hope that the parties will be able to discuss and agree. But otherwise, the court will need to, again, adjudicate. And it can be that summer holidays are long, so it would be split within the holiday. Whereas for some shorter holidays like Chinese New Year, Easter, where it's maybe just a week or 10 days, it's not really feasible to split down the line, down the middle, because you may not be able to take the children away for holiday. In that case, it may be that one person takes Easter and the other takes Chinese New Year, that kind of arrangement. But it all is dependent on how the parents want to divide the time.
Okay. So you've summarized that quite quickly, but it is personal, right? It depends on a lot of different things, but I think that's a great summary. What about relocation?
Relocation. So I often advise parents who intends to relocate that they must have care and control of the children, because if you don't have care and control of the children, if you're not the primary carer, it's almost impossible for you to successfully get the court's approval for you to take the children and relocate out of Hong Kong to a different country. But if you're the parent with care and control and you do want to relocate, and assuming the other spouse or the other parent doesn't agree to the relocation, then you need to make a relocation application to court to explain and convince the court why this move is going to be beneficial for the children, not for you, but for the children.
It's a crucial statement there. It's not about you. It's for
exactly.
Is it a better school? Is it a better option?
Environment.
For the children?
Is there going to be better support network over there? Especially if you're going to, let's say, if you're an expat and you're going to your home country, maybe you have more family to support you, looking after the children, etc. So the judge would really want to know, okay, are the children familiar with that place that you're relocating? Would you have support? Would there be any disruption to their education? And then after looking at many factors, then the judge would say, okay, I grant the relocation or not. Yeah.
Okay. How often does relocation come up in your practice? Is it a...
I would say during the COVID years, more so. Or even before, more so, when there are more expats in Hong Kong. There's a lot of expats who, at the time of divorce, they would feel like there's no reason for me to be in Hong Kong because I've relocated with my spouse to Hong Kong. So they want to go back to their home country. But relocation application can be costly and lengthy as well. So nowadays, I see more and more parents coming to an agreement on relocation, be it that, okay, I allowed you to leave, but maybe postpone that until 2 or 3 years' time. And so they negotiate on the timing of it. Or that they negotiate, okay, if you do relocate, then I get more access. For example, during the holidays, I get to spend more time with the children because otherwise during school term, I don't really see them as much as you do.
Right. Okay. So in terms of I guess, the common disputes, the children being part of that decision-making process,
Mm.
where does that lie in the court,
Mm.
in the eyes of the court, essentially?
Yeah. So the children's wishes and feelings
Yes.
would be reflected first in the social investigation report, where the social welfare officer would interview the children. If they're too young, then probably not. But if they can articulate themselves, then there would be an interview. And there may even be, let's say, if the children are believed to be manipulated by a parent to say certain things, then there may even be a child psychologist report where a child psychologist would speak to the children to unravel, okay, why do you not want to see dad? Why do you hate mom, etc. So there may be two experts where they would, by talking to the children, reflect what their wishes and feelings are. The judge may or may not need to listen to their views, but the older they are, the more weight that what they say would carry. And so when we're talking about children, let's say teenagers, who are very adamant that they want certain things. Let's say, I don't want to see dad, or I only want to see dad for one day a week or something, and they must justify it for reasons. Then the court may accept that, okay, this 14-year-old, 15-year-old, if I still force them and make a court order to say that they must see dad 3 times a week, they probably won't leave the home, and there's nothing you can do. You can't be dragging them out of home when they're already a teenager, and it's not to the best interest anyway. So the older the children are, the more the judge would take into account their feelings and wishes.
Okay. Again, a lot of it's a very personal approach to it. That's where you come in with the wishes of the family, with the court, and then what's recommended.
Yes.
So we talked about finances. We talked about custody. I just wanted to touch on prenups, because that's something that comes up quite a bit. How does the court see prenups, and what's your advice to clients, maybe before they get married, or if they're going through this process and have a prenup?
Yeah, so there may be a misconception that prenups are not enforceable in Hong Kong, and therefore there's no need to do prenups. But actually, no matter in the UK courts or in Hong Kong, the courts have shown an increased respect for prenuptial agreements that meets the requirements, certain requirements. So generally speaking, if the prenup meets those requirements, then the court will adopt the terms of the prenup. And what are those requirements? So first of all, the prenup needs to be done at least 28 days before the wedding. The reason is because if it's too close to the wedding, there's a chance that either parties may try to say, oh, I had pressure to sign because otherwise the wedding invitations are all out, etc. I would lose face if I were to cancel the wedding. So it has to be a certain time before the wedding. That's number one. Number two, both parties need to have their own legal advice. Again, it's to avoid one party later on arguing that, okay, I obviously understand English, but I didn't understand the legal implications of what I'm signing. Because in order for you to truly understand the legal implications of the prenuptial agreement, you need to first understand what you would otherwise have, what are your entitlements in a normal course of divorce without a prenup, in order to know what you're giving away, right? So they need to have their own lawyer. And then the third requirement is that they need to give financial disclosure. And this is something which some of my clients feel quite reluctant because they don't want their fiance to know how wealthy they are. But then I always advise them, the more financial disclosure you give, the more protective the prenup is going to be, because again, it avoids the other person later on, somewhere down the line, to say that, oh, I didn't know you're that wealthy. I didn't know I was giving away so much of my rights to these properties and companies that you have. So the more you disclose, the better it is for yourself. And then finally, obviously, there shouldn't be any pressure or undue influence or duress to sign the prenup. And then there's also this, the job of lawyers is to ensure that the terms of the prenup are at least fair and reasonable. And what you mean by fair and reasonable is that the terms has to at least cover the basic needs of the parties. Because if, let's say, the terms of the prenup are such that one person, being the financially weaker party, for instance, will not have enough to sustain his or her living, then the courts would say, okay, I can't just blindly follow the prenup because the other person don't even have enough to live by. In that case, the court will ignore the prenup. So the job of the lawyers is to ensure that whatever terms is in the prenup is going to pass the test of the court in the sense that it is going to meet the basic needs. Doesn't have to be the generously assessed higher needs, but at least the basic. So there are different types of prenups. Some would be that for young, financially independent couples where they don't have much financial disparity, they can agree to a prenup where they each keep what's under their own name. So they only need to share what's under joint names because they've intentionally put that asset under joint names. And that would work if they're both young, financially independent, etc. But there are also some scenarios where there is huge financial disparity between the two parties. For instance, a super wealthy second generation marrying an ordinary person, for instance. For instance, there's also, I have a lot of clients who are really wealthy businessmen marrying, let's say, a 20-year-old model or someone who is in arts and don't really intend to work. They intend to be a homemaker and be a mother of the children. In those kind of cases, the type of prenup I just explained wouldn't work because if we were to each keep our own assets and only share what's joint, if there's no joint assets, then there's nothing to be shared, right? So in those kind of financial disparity cases, their prenups need to consider what we call a Hollywood style prenup, which is maybe the longer the marriage, the bigger the lump sum or the amount that's going to be given to the financially weaker party. So it may be that, okay, we've married for 5 years, you get 10 million, 10 years, you get 20 million, etc. And some would even say, okay, we are married with children, I pay you extra amount, or I give you a property on top of that, or 10 years later, I give you not just a property, but a holiday home for you and the children to enjoy, etc. So it's all tailor-made. It's up to the couple how they want to negotiate and discuss the terms, which is why I often say to people when they say, oh, prenups are only favorable to the financially stronger party. It's not always the case because if a prenup is done properly, the financially weaker spouse or the financially weaker party should have an equal right of negotiating what she, let's say, were to be given in the event of a divorce. And she has the rights to say, okay, if I were to be married for you 10 years, I need to have X, Y, Z kind of scenario. So it's not just, it shouldn't be a one-sided kind of negotiation or discussion.
Right.
Yeah.
That's good advice. So we've covered a lot of touchy subjects, important, just demystifying divorce from all different aspects. I just want to ask a few fun, thought-provoking, lighten the mood a little bit. So I guess one of the first ones is you see a lot of crazy stuff in your practice. What's the wildest thing that you've seen the courts make a decision on that was unexpected, let's say?
Okay, that's a recent case. Well, a case that I'm still handling, actually, where we're talking about this daughter of a super billionaire in Hong Kong. We're talking about her assets worth probably 200-300 million. Her income maybe up to $500,000 a month, that kind of scenario.
Okay.
She's married to my client, who's the husband in this case, and also the homemaker. So it's a non-stereotypical kind of structure in the house. My client don't earn much because he has always been looking after the children, always been provided for by the wife and her family. And we applied for maintenance for him because at the time of divorce, she not only kicked him out of their mansion, but she also stopped paying for everything. And he was working partly for one of her father's businesses, and they sacked him, obviously, immediately when the divorce started. So he really had nothing to sustain his own living, only maybe relying on the generosity of his stepmother at that time, who fortunately is living in Hong Kong. In spite of these circumstances, the judge still awarded a very meager sum of maintenance. Maybe we're talking about less than 100,000, when the wife probably is spending like $500,000 a month on herself. And we asked for legal cost provision, which is something that more and more individuals need to apply for. Legal cost provision is when you don't have the means to pay for your lawyers, but you can't qualify for legal aid, the government subsidy. For those kind of cases, they can ask the court to order the other spouse to pay an amount for them every month to meet their legal costs. Otherwise, you're not on equal playing fields. So we asked for legal costs provision. And again, in spite of this, we call it David and Goliath kind of situation, the court still believes that I'm not going to order any legal cost provision because he can work. He's a man, he can work, he can try to maximize his earning capacity, etc. So that case really caught us off guard. I hesitate to say that there's been any gender bias because the law shouldn't have gender bias. But I think sometimes there are some preconceptions that people do have about what a man or a husband should or should not be doing. So that's an unfortunate one.
Interesting. I have another question for you as we wrap up. What would you say is the one myth about divorce in Hong Kong that you, as a leading family lawyer here in Hong Kong, would like to dispel?
One myth.
You can give 2 or 3 if it's easier.
Actually, there's so many myths because I have so many questions from clients. Some mothers seem to believe that if they're not the one who has the income, then they couldn't fight for care and control of the children, which I have to say, no, it's not like that.
It almost seems like the opposite.
yeah, because you then ask for children's maintenance. That's why there's children's maintenance. But a lot of perhaps husbands try to convince their wife that they're not going to get custody by this way. So that's one thing that a lot of people seems to have a misconception on. Another misconception is that people, one of the questions you say, if my spouse wouldn't agree to a divorce, then I just need to wait for 1 year or 2 years separation before I can file for divorce because otherwise, it's never going to happen. But again, I often tell my clients, you can apply for divorce under the grounds of unreasonable behavior. You don't need to wait 1 year separation, and you don't need to worry if your spouse doesn't agree, because sooner or later, trust me, they will accept reality and agree to the divorce, because that's what I see in over 99% of my cases. So that I think that's 2 things which people usually have a misconception on.
And one final question. What if you go through the divorce process and everything's done and then they don't pay?
We do have those situations, and you'll have to apply for enforcement.
Okay. So it's another court process, essentially.
Yeah. I would have to accept that it's a tedious process because when the other person doesn't pay and you're the recipient, you're already lack of the financial means, and the other person's owing you money, but still you need to spend the time and legal costs to take out enforcement proceedings against the other party to compel that person to honor the terms of the court order. But that's how the court process is.
Okay.
Yeah, that's something that family law practitioners are very, we find that it's very unsatisfactory, the process, because even the enforcement proceedings itself may take a while.
And costly as well. Yeah.
Yes, but that's unfortunately. So that's why in most divorce settlements, we try to encourage parties to go for a clean break settlement if the asset can allow that. For instance, if the asset pool is big enough, then instead of having ongoing maintenance where there's an ongoing obligation to pay, we just say, okay, that person needs to pay X amount of assets, and then once it's paid, then you don't need to worry about the other person not complying with the order anymore.
Okay. Well, I have to say we have covered so much, and I think there's some key themes that I've picked up on, which is the process in Hong Kong is straightforward, but there's a lot of things that you need somebody that is an expert in those areas to navigate, because it's all very personal. Each situation's different. We also talked about just the general keeping your emotions over here and going through the process from the process standpoint, and working with your lawyer to save the time to work together to make sure it comes out with a good outcome for everyone that's involved, because there is lots of different people that need to live and move on from the divorce process as well. So just thank you for all of your insight, and we appreciate it. We've had you on before, as mentioned, and I'm sure we'll have you on many times again, but do appreciate it. Is there anything that I didn't cover today that you want to make sure is included in this chat?
Just want people to know that actually having lawyers are not necessary for divorce proceedings, especially for consensual divorce applications. It's also possible to self-represent, to act in person. And actually in the judiciary website, there's, as I understand, a lot of forms and templates where a person can find the relevant form to fill in the divorce petition, for instance. Not everyone needs a lawyer, but if the cases or the case has issues which are complex, and if the person has no confidence to go speak in front of a judge, etc., then I think it's best to engage a lawyer to represent him or her.
Excellent. Yeah. Options. I think that's the key. I think you've done a great job at just helping it not be so intimidating. The whole process.
It shouldn't be.
There's options. There's options for every scenario.
Yes.
So thank you again. Well, that wraps up our chat today on demystifying divorce here in Hong Kong. And thank you, Jocelyn. Where can we find you? Is it straight on LinkedIn, or prefer to go through Withers, or a bit of both?
Either way, or if you just type my name, Jocelyn Cho, Hong Kong, you'd see a lot of platforms that I'm on, which you can find me.
Excellent. And we'll certainly have this all written up on Little Steps Asia as well. So we'll have all the links to find Jocelyn. So thank you, and appreciate it. And we'll see you next time.